faithfully convey value and interpret global good books. Hello, this is Sally's Book Talk. Today, I'm going to introduce this book to you. A good marriage should protect both property and love. If you ask someone what a good marriage is, many people would answer that a marriage with love is a good marriage. And as long as there is love, the marriage won't fall apart. But often, when a marriage actually breaks down, people suddenly realize that what sustains a marriage shouldn't be just love. Um, the author of this book believes that only by understanding the laws and regulations in marriage and establishing a sense of security in marriage can we build a long-lasting marriage. It can not only help us alleviate anxiety in marriage, but also truly help us protect our rights when the marriage dissolves. The author of this book, Wu Jizhen, is a professional divorce lawyer, especially skilled in handling major and complex divorce litigations. She has handled many socially influential marriage cases and has provided private advisory services to clients such as entrepreneurs, NPC deputies, and CP for PCC members. As an expert in the field of marriage law, Lawyer Wu's comments are often seen in media, such as CCTV, Xinhua News Agency, and Guangzhou Daily. She also won the title of Sina's Top 10 Influential Legal Bloggers in 2018. Oh, wait, in this book, the author, through solid legal theoretical knowledge and rich practical experience, introduces the essence of marriage law to us in an easy to understand language and tells us how to build marital security in practice, giving marriage an insurance. Next, I will explain this book to you from three aspects. First, how to protect your property in marriage. Second, how to protect yourself when facing a partner's infidelity. Third, how to protect your rights when wanting a divorce. Let's start with the first aspect. How to protect your property in marriage. Many people feel that marriage is a kind of security for the future. Since they have chosen marriage, they should be prepared to tolerate and give. Especially Chinese women, influenced by traditional concepts, are more likely to make personal sacrifices for the family. They feel that even if they divorce later, the system of joint marital property can provide them with some security, so they don't have the awareness to protect their property. But in fact, the marriage law emphasizes the separation of private property. Only wealth created after marriage belongs to the joint property. But if there is a misunderstanding about joint property, it is very likely that you won't get legal protection during a divorce. In fact, since the founding of our country, China has enacted 2 marriage laws, undergone 1 revision, issued 3 sets of judicial interpretations, and finally implemented the Civil Code in 2021. Regarding property, the overall trend is towards isolation of private assets. In marriage, it's becoming harder for unwilling partners to gain property without contribution, while those who contribute more receive greater benefits. So, before learning how to protect property, we must first distinguish between personal assets and joint marital property. According to China's Civil Code, the Marriage and Family section establishes 3 fundamental principles for distinguishing personal and joint property. First, property acquired before marriage belongs solely to the individual, meaning assets registered under one party's name before marriage registration without contribution from the other spouse are personal property. For example, houses or cars purchased before marriage. Moreover, personal property doesn't convert to joint assets through prolonged marriage. That means, even after 10 or 20 years of marriage, premarital assets remain individually owned. For instance, if a man had 300,000 savings and a property before marriage, then sold it to buy a new home using those funds to care for parents after marriage, although purchased during marriage, since the funds came from premarital assets, this remains his personal property despite the form change. The second principle, property acquired during marriage is jointly owned, including salaries, bonuses, labor income, business profits, investments, inheritances, or gifts, unless specified otherwise in the gift contract or will. The third principle,
Income generated from premarital assets during marriage generally belongs to both spouses.
For example, if the husband owned a company before marriage that both spouses later managed together, then the company's post-marriage income becomes joint property with two exceptions. Fruits and natural appreciation from premarital assets remain individual. Let's explain these two concepts. Fruits are divided into natural fruits and civil fruits. Natural fruits refer to proceeds from natural properties, like fruit from trees. Civil fruits mean legally derived proceeds, such as deposit interest or stock dividends. Natural appreciation refers to the increase in property value without any contribution of time, intellect, money, or labor from the spouses, solely due to market factors. For example, the appreciation of premarital property due to rising home prices after marriage is natural appreciation as opposed to active appreciation. The portion from active appreciation belongs to the joint marital property. For instance, if one party pays the down payment for a house before marriage and both jointly repay the loan after marriage, then the appreciation of the property belongs to the joint property. Now, another example. If stocks worth 1 million before marriage increase to 1.5 million by divorce, whether the 500,000 gain is personal or joint property depends on whether the stock account was operated during the marriage. If it was operated, it's likely considered an investment behavior, meaning intellectual labor was invested after marriage, belonging to active appreciation, so the 500,000 gain becomes joint property. And so,
As we said earlier, personal property does not convert to joint property due to the continuation of the marital relationship. Winning in
however, note that in some cases, personal property may convert to joint property. For example, transferring property after marriage, like registering one's car or house under the spouse's name, is considered a gift, thus turning that personal property into joint property, right? So, another case is commingling of assets, where premarital and postmarital properties are mixed, making it impossible to distinguish between them. During divorce, the party claiming personal property cannot prove which assets are personal and which are joint. For instance, the wife had 200,000 in savings in account A before marriage. Before marriage, the husband gave her 100,000 as a betrothal gift, also deposited into account A. After marriage, the wife's monthly salary is also transferred into account A. Daily living expenses and major purchases are all spent from account A. After 2 years, the account still has only 300,000. In this case, it's hard to distinguish how much is premarital property and how much is postmarital. All right, we previously discussed the three fundamental principles for distinguishing personal and joint property. Additionally, personal daily necessities and compensations received for bodily injuries also belong to personal property. For example, women's clothing, cosmetics, medical expenses, disability living allowances, etc. Of course, learning to distinguish personal and joint property can encounter issues in practice. For instance, many couples have no way of knowing how much property the other party has when divorcing.
Because you can't search for a person's property by name, nor can you check their company accounts with just their name.
Even with bank card information, accessing transaction history faces various restrictions. For example, usually you can only obtain the other party's bank records from the year before filing for divorce. But if your spouse bought financial products lasting over a year, 1 year's records won't reveal anything. But we may not be able to ensure we lose nothing in marriage. But at least we should learn to protect our major assets in marriage. Now let's discuss the two most common property issues in marriage. Betrothal gifts and property. First, betrothal gifts. While controversies around betrothal gifts are increasing, they remain customary in many areas, and disputes over them are common in marital conflicts. In many parts of China, during engagement, the groom gives the bride a certain amount of money or physical property. For example, gold and silver jewelry as betrothal gifts. Like dowry, these are traditionally personal gifts to the bride, constituting her personal property.
But note, not all such property is legally recognized as betrothal gifts.
Courts typically consider four key elements: local customs, marriage intent, property value, and timing of gift. Generally, the stronger the local custom, the higher the value, and the closer the gift timing to marriage registration, the more likely it's recognized as a betrothal gift. Betrothal gifts belong to personal property, but if received after marriage registration, they're usually considered joint property. In practice, physical or cash gifts often lack receipts, making proof difficult. Typically, whoever controls the property keeps it. If betrothal gifts are used to buy property, whether the house becomes joint property isn't definitive. Some courts require the wife to prove the funds came from betrothal gifts. Otherwise, it's considered co-investment, dividing the property by contribution ratio. Other courts require the husband to prove the funds were betrothal gifts. Otherwise, the property belongs to the wife. Clearly, clarifying the nature and amount of betrothal gifts beforehand is important. Yes, it's protection for both parties. So can betrothal gifts be reclaimed? The second judicial interpretation of the marriage law lists three situations where requesting return of betrothal gifts is permitted. The first situation is when the couple hasn't registered their marriage, but if they've lived together, the request to return the betrothal gifts might be partially deducted, and so couples sum. The second situation is when the couple has registered their marriage but hasn't lived together or lived together for only a short period. The third situation is when the betrothal gifts were given before marriage and caused financial hardship to the giver. That means after the man gives the betrothal gifts, he cannot maintain a basic standard of living in the local area by his own means. Additionally, if the man, according to local customs, gives the betrothal gifts directly to the bride's parents, it becomes the property of the bride's parents, but the man can still request its return according to legal provisions. Having discussed betrothal gifts, let's now talk about a more widely concerned issue: property. Lawyer Wu believes it's most beneficial for either gender to buy a property for themselves before marriage. Typically in divorce, if the couple has only one jointly owned home, the court often awards it to the party who gains custody because the child needs a stable residence. However, if one party in the marriage owns a premarital mortgaged property, the court will directly award the property to them. As for the portion of the mortgage repaid jointly after marriage, they only need to compensate the spouse a sum of money. The amount of this money is half of the jointly repaid mortgage amount after marriage, plus half of the corresponding appreciation in the property's value. For example, if you bought a property worth $1 million with a mortgage before marriage, and after marriage, you both jointly repaid $100,000, and at divorce, the property appreciates to $1.5 million, then you need to compensate the other party $300,000, and the property belongs to you. If there was no joint repayment, then the buyer doesn't need to give the other party any money. However, in reality, many people rely on parents to fund property purchases, especially since parents often help with the down payment, leading to questions about who owns the property. Chinese law stipulates that if parents fund the purchase of a house for both parties before marriage, the funding should be considered a personal gift to their own child. But if the parents explicitly state that the gift is to both parties, that's an exception. That means if parents fully fund the house and register it under their child's name, then the property rights belong to the child. If parents only partially fund it, then the property ownership belongs to the child. But the portion of mortgage repayment after marriage and property appreciation belongs to both spouses. Whoa. But if parents fund it and the property is registered under the other party's name or both names, then the ownership becomes controversial. Some courts believe that the property share should be based on the proportion of the parents' funding. Other courts believe the property is jointly owned with each party holding 50%. Therefore, Lawyer Wu strongly advises written agreements specifying funding amounts, sources, nature, property ratios, and mortgage responsibilities to avoid rights infringement. But ordinary people might find this too complicated, making marriage feel like starting a business. How can you marry like this? Still, having awareness about protecting your assets is possible. For example, have parents provide written documentation confirming funds are gifts to their own child, either notarized or at least via WeChat or text message. The previous points cover premarital property precautions. Let's discuss what to note when buying property after marriage. As mentioned, property acquired post-marriage is jointly owned, but reality is more complex. Whose name goes on the deed, and who provides the funds?
Different combinations yield different outcomes, extremely complex, and mistakes can cause heavy losses.
We'll focus on two key points: whose name is on the deed and who pays. Many think the name doesn't matter since it's joint property anyway. But in practice, property transfers or mortgages don't require spousal signatures. Even for joint property, the named party can directly dispose of it, a fatal flaw in marital security. So, when buying property, clearly negotiate whose name goes on the deed. If both names are used, specify ownership percentages on the deed. Name registration applies not just to new purchases, but also property swaps during marriage. For example, you own premarital property, but need a school district home after marriage. Short on funds, you sell the original and take joint loans. If the school district home is under the spouse's name, the entire property becomes joint. If under your name, as previously noted, premarital assets retain ownership despite form changes, so this remains your personal property. After discussing names, let's address funding sources. If jointly funded post-marriage, it belongs to marital property. But what if parents provide the funds?
The judicial interpretation of the marriage and family section of the Civil Code provides the answer. If after marriage, one parent funds the purchase of real estate for their child and registers it solely in the child's name, Mio and Slaw 5, it is considered a gift only to their own child, and the property should be recognized as personal property.
Suppose after marriage, the man's parents provide $3 million to buy a house registered solely in the man's name. Then this house belongs to the man's personal property and has no relation to the woman. But if the property is registered under the woman's name or both names, it becomes joint marital property. Okay, this is if both parents contribute funds, the situation becomes more complex. In this case, even if only one child's name is on the deed, the property is co-owned according to the funding ratio. If both children's names are written, then it belongs to jointly owned property by the couple, each holding 50%. Besides property issues, another point to note is that renovation funds can also lead to disputes. Many people think it's reasonable for the man to buy the house and the woman to fund renovations. But Lawyer Wu believes that whether before or after marriage, neither party should let the other fund renovations. Instead, they should convert the money into property funding. A possible scenario when one party buys the house and the other funds renovations is that the property ownership doesn't belong to the party who funded the renovations. For example, a couple is about to marry. The man's parents are responsible for buying the house, the woman's parents for renovations, and the property deed is in the son's name. And in this case, the house belongs to the man and the post-marriage mortgage repayments are made by his parents, so it's not joint marital property. The woman's money went into renovations, and after divorce, she can only get some appliances which are incomparable to the house's value. So if both families are financially sound, it's best for each to take out a mortgage on a property, both enjoying first home benefits. But if one party is wealthy and the other is financially disadvantaged, they should decide whether to buy separately or jointly invest in a property and agree on funding ratios and ownership shares. Property security is a very complex topic, What we've discussed above are just some common situations. If you encounter complex property issues in reality, you should still seek professional advice from a lawyer. All right, we've finished discussing property security. Next, in the second aspect, let's talk about another topic many people focus on in marriage.
Infidelity destroys the emotional security in marriage. Once loyalty is lost, the marriage loses its foundation.
But in practice, many people don't know how to protect their interests when facing infidelity. Marriage law doesn't provide a clear definition of infidelity. Lawyer Wu categorizes infidelity into 4 types: emotional affairs, cohabitation, bigamy, and adultery. From the perspective of marriage law, emotional affairs without physical relations violate marital fidelity obligations but generally carry no legal penalties.
While infidelity violates marital fidelity obligations, it generally has no legal punishment.
The second type, cohabitation, refers to married persons living continuously with a third party. In practice, this usually means continuous cohabitation for over 3 months. The third type, bigamy, means having a spouse while living with another as husband and wife, including both registered marriages and unregistered relationships perceived as marital. The fourth type, adultery, refers to sexual relations with others while married. Among these, bigamy and cohabitation are statutory faults and legal grounds for divorce. Courts should grant divorce for these, but emotional affairs and adultery aren't statutory grounds. Even if sued for adultery, courts usually give reconciliation chances and deny divorce. So what legal responsibility does the unfaithful party bear? Many immediately think leaving with nothing, but China's civil code has no such provision, meaning the unfaithful party doesn't forfeit or get less property. Leaving with nothing lacks legal basis. Does infidelity then lead to reduced property shares? The answer remains unclear. Current law only states courts may consider favoring the innocent party during divorce rulings. This doesn't mean Chinese law offers no protection to innocent parties. Per China's civil code, in cases of bigamy or cohabitation, the innocent party has the right to claim compensation. Such provisions lead many to misunderstand that adultery isn't illegal, while cohabitation is. As long as there's no cohabitation, intermittent sexual relations carry few legal consequences. Thus, in recent divorce cases, even without cohabitation, courts increasingly support compensation for innocent parties. So when encountering a spouse's infidelity, how can we best protect our interests? Lawyer Wu offers 4 suggestions. First, quickly calm your emotions and clarify what you truly want. If seeking divorce, promptly engage a family law attorney. If reconciliation is desired, find appropriate methods. Second, don't let them know you've discovered the affair to avoid alerting them and complicating evidence collection.
Third, gather evidence while quickly assessing family assets, properties, deposits, business finances, debts, and credits.
Evidence collection during infidelity concerns many people. We'll focus on 3 evidence types: audio recordings, WeChat or text messages, and photos or videos. Audio methods, conversations with spouse or affair partner, placing recorders at home or in cars, preserve original devices, address names clearly, confirm relationships and financial gifts. The second type, WeChat or text message evidence. Screenshots lack legal validity as they're not from original devices and can't be authenticated. Courts typically dismiss them. Proper method, merge and forward chats to yourself, then delete the forwarding record. This avoids detection while preserving court-admissible evidence from your own WeChat interface. If possible, record video evidence showing chat content, WeChat ID, and linked phone number for verification. Text message evidence is harder, since chats can't be merged or forwarded. Securing the original phone is essential. Only by presenting the original device in court can text messages be authenticated and accepted.
Yes.
The third type, photo or video evidence. Most effective method: search spouse's phone, computer, or email for saved photos and videos. Immediately copy any findings to your USB drive or hard disk. Simply photographing with your phone prevents authenticity verification against photo manipulation. So note that long-term spying on a spouse during evidence collection may violate privacy rights. Using phones or cameras for secret recording at home isn't considered severe infringement of legal rights in principle. But whether prolonged secret recording infringes privacy remains controversial. So the author suggests identifying when your spouse might bring the third party home for targeted recording. However, evidence obtained through pinhole cameras is legally prohibited. Thus, such evidence is invalid. Fourth point, after discovering infidelity, properly handle assets in your name with a family lawyer's help. Avoid self-handling.
These steps help victims gain advantage in divorce negotiations or litigation.
Divorce negotiations depend on each party's leverage to make concessions. Litigation divorce focuses on evidence each party possesses. Thus, in marital crises, staying calm is crucial. Beyond infidelity, safety threats like domestic violence, especially against women, severely undermine security.
When facing domestic violence, call police, seek help from relatives, friends, lawyers. Avoid the don't air dirty laundry mindset that enables escalation.
Per civil code, domestic violence is legal grounds for divorce, with victim compensation rights. Best evidence is on-scene recordings. Without it, call police or seek neighbor help. Neighbor testimonies can also assist. Beyond infidelity or violence, incompatible values or lifestyles can cause marital breakdown. Everyone hopes for eternal happiness when marrying, but not all achieve it. How to face a broken marriage. Protecting your rights during divorce is our focus. Thirdly, divorce has two main methods: litigation and mutual agreement. If one spouse seeks divorce, they can directly file a lawsuit in the People's Court. People's courts must conduct mediation in divorce cases. If the relationship is irreparably broken and mediation fails, divorce should be granted. If the court doesn't grant divorce the first time, and the couple has been separated for a full year, and if one party files again, divorce should be granted.
Divorce cases are essentially about fighting over kids and assets. The asset fight is just about digging up the other side's hidden stuff. So you gotta strike first, especially if you're weaker. Filing first can lock down their assets.
During the whole lawsuit, they can't move assets in their name. Even with a business, they probably can't shift profits right away. And also, during the breakup phase, big spending and investment losses get super sensitive. They're often seen as unauthorized asset disposal, so you might have to pay back half the cost or loss. And a good lawyer can show you how to freeze and seize their assets, one after another.
But the key is, if you're set on divorce, you gotta act fast.
If you don't hold the main assets and just wait around hoping they'll come back, once they file, it usually means they've already handled all the assets. But fighting a divorce takes time, 6 months to 2 or 3 years, and it costs money and a ton of time. So lots of couples hope to settle out of court and avoid the legal battle. Next up, how to protect your rights in a settlement divorce. The author covers 3 points. First, how to negotiate better for yourself in divorce talks. The book says divorce settlements hinge on 2 things: case factors and outside factors. To get the upper hand, tackle both smartly. Case factors are mostly about predicting the lawsuit outcome, based on evidence. More evidence means better odds. So, your prep work and evidence skills before court are key. If needed, getting a solid lawyer helps win the case. Outside factors cover more ground, like tailoring your strategy to their background, status, and personality. Say, if the guy cheated with a coworker and he's big on face saving, he might fear you'll tell everyone at work. Then in talks, she can hint how settling fast helps his career. Second point, when can you get a bigger slice of the pie in divorce?
China's civil code specifies 5 situations for reduced or denied property division: hiding, transferring, selling off, squandering joint assets, or fabricating joint debts to seize the other party's property.
If one spouse commits these acts, the other can request a larger share during property division. So, discovering such behavior post-marriage also allows requesting redivision of joint property. Beyond statutory extra shares, 3 discretionary cases exist. When one party is at fault, the innocent party may receive more. Additionally, the child custody holder may receive more, and women may receive more, but in practice, judges usually grant only modest extra shares beyond equal division. Points to note in uncontested divorce. Third point, what pitfalls exist in divorce agreements? The book lists 8 pitfalls summarized into 2 categories. First, beware these agreement clauses, like no joint property exists, assets are fully divided, all other property belongs solely to respective owners. Advice. Explicitly list all assets, state no other assets exist, and specify liability for hiding assets. Second category, beware of contractual non-fulfillment, e.g. refusing household registration transfer, property transfer assistance, moving out, child support, or visitation rights.
Counter this by specifying substantial penalties for non-compliance to increase breach costs.
With that, we've nearly covered a good marriage protects property and love. And as times change, understanding marriage law has become essential for adults. The goal isn't to hurt the other, but to let you give freely within a secure framework. Only with true affection like this can marriage endure.
As the title states, a good marriage safeguards both property and love.
That concludes our book interpretation. Reading notes are below the audio. Until next time.